Welcome to Series 3 of the HIP Talks podcast, a series of discussions on legal issues hosted by Hugill and Ip solicitors. The firm provides high-quality legal services with integrity, professionalism, and respect for its clients and the community. An outstanding team of lawyers who have achieved exceptional results and recognition in the areas of dispute resolution, corporate and commercial, private client, family, employment, business immigration, and data privacy.
Hi everyone, I'm Jacqueline Cheng from Hugill and Ip, and I'm here today with Adam Hugill to talk about Hong Kong bonuses. Hi Adam.
Hi Jackie.
Hi, I understand that bonuses are a common feature in most employment contracts, and that about 90% of employees in Hong Kong expect to receive some form of annual bonus each year. What sort of bonuses are actually common in Hong Kong?
Bonuses can take many forms, from being very simple to being very complex. The nature of the bonus depends on really what the purpose of the bonus is. The reason bonuses can become very complex, and certainly for high-value bonuses, is that they must balance rewarding staff, maintaining your high earners, with balancing the costs to a business. The most simple and standard form of bonus in Hong Kong is what we call the traditional end-of-year or Chinese New Year bonus. It's usually called a 13-month bonus. This tends to provide 1 month's extra pay, usually at the end of the calendar year or at the lunar year. The timing of the bonus and the amount of the bonus is fixed, and so it's not really reliant on appraisal scores, KPIs, or the performance or achievement metrics of the employee.
Does this mean that all employees are actually automatically entitled to receive this 13th month bonus?
For employees, unfortunately not. There's no such thing as a mandatory bonus in Hong Kong. An entitlement to a 13-month bonus, or indeed any type of bonus, depends on what's written in your employment contract. Now, it is possible to become entitled to a 13-month bonus or some other type of bonus through custom and practice. This means that something has happened consistently over a long period of time and therefore becomes part of an employment contract, albeit an unwritten part of the contract. Unfortunately, it's very difficult for employees to prove that a custom and practice exists, which gives them the right to receive a bonus.
What is this high complex value bonus that you mentioned before?
Okay, so before we go on to consider complicated bonuses, we should talk about the form of bonus protection that's included in the Employment Ordinance. The Employment Ordinance, of course, is the key piece of legislation that governs employment issues in Hong Kong. What the Employment Ordinance does include protections for what it calls the end-of-year payment. Now, an end-of-year payment means an annual payment or annual bonus, which is of a contractual nature, but specifically does not include an annual payment or bonus that we call gratuitous or that's paid at the discretion of the employer. So this definition obviously includes a 13-month payment. However, because it's worded quite widely, it can cover many other types of bonuses, including the complex bonuses or high-value bonuses that we see associated with the financial services sector. It's this part of the Employment Ordinance which gives rise to disputes between employers and employees. In some cases, these disputes can run to multi-millions of dollars.
So what does the Employment Ordinance do that creates all of these multi-million-dollar disputes you speak of?
Well, if a bonus falls within the definition of end-of-year payment, certain rules automatically apply to that bonus, whether or not similar rules or even conflicting rules are included in the employment contract. For an example, let's assume the bonus period is a calendar year, 1st of January to 31st of December. If an employee has worked for at least 3 months of the bonus year and their employment is terminated by the company, but not for gross misconduct, then the employee is entitled to receive a pro rata bonus. The right to a pro rata bonus payment does not arise, however, if you resign, unless, of course, it's a constructive dismissal, which is a totally separate area. So what this actually means for employers is if you were to terminate an employee on the 31st of March, no pro rata bonus is payable. However, if you wait for 1 day and terminate them on the 1st of April, a pro rata payment would be payable. It doesn't sound like much, but if you're working for a major industry and you're running an HR operation for large-scale redundancies, the difference of 1 day could be a substantial business cost. It's also fairly usual for employers to pay bonuses during the first few months of the following year. So if the bonus year runs January through December, bonuses might get paid end of the following January, February or March. One of the rules in the Employment Ordinance is that if an employee has worked for the entire bonus year, the employee is entitled to receive that bonus whether or not the employment is terminated prior to it being paid. This even applies if the employee is dismissed for gross misconduct or if the employee resigns.
But Adam, Isn't it usual for an employment agreement to say that you must have worked for the entire bonus year in order to be entitled to receive any bonus, or that you must be in an employment and not serving your notice period in order to receive a bonus?
Yes, this is typical wording that appears in many employment contracts. However, provided you can establish that your bonus falls within the definition of end-of-year payment, the Employment Ordinance will automatically void any contractual term which is to the contrary. Going back to the definition of end-of-year payment, and that is an annual payment or annual bonus which is of a contractual nature, but specifically does not include any bonus which is gratuitous or discretionary, we need to look at the key parts. That is the words contractual nature and payable only, as it relates to discretion of the employer. Putting the simple 13-month bonus to one side, the obvious type of bonus that falls within the definition is a contractual performance bonus. In particular, performance bonuses are paid with reference to a fixed criteria or key performance indicators. Such performance bonuses are common in sales executive contracts, where the sum of money paid is directly referenced to the sales that the employee has made, and it's often based on a very clear formula. Other professions, for example recruitment consultants, receive performance bonuses upon achieving certain revenue targets, and there's a formulaic bonus that's paid. Indeed, lawyers and other professionals also might receive contractual performance bonuses that reference billable hours and fee revenues. In many ways, contractual performance bonuses are similar to commissions, apart from the fact that commissions tend to be paid throughout the year, either monthly or quarterly, and annual performance bonuses are only paid once per year. The important thing with a contractual performance bonus is that part of the contract includes fixed or defined terms on how the bonus is calculated. Hopefully the terms will be drafted very precisely and clearly so that everyone can apply the formula and arrive at the same figures. The reason for this is because lawyers hate doing maths.
So I'm guessing that things start getting more complicated if the bonus isn't of a contractual nature, or if it is payable only at the discretion of the employer?
Yep, that's right. Most issues come from discretionary bonuses, and whether or not the bonus is genuinely a discretionary bonus or not. To make matters more complicated, there can also be hybrid bonuses that include elements of both contractual and discretionary bonuses. As a starting point, under Hong Kong law, there's a general presumption that a bonus is not a discretionary bonus unless the employment contract specifically says that it is. Discretionary bonuses might simply state, your right to receive a bonus is entirely discretionary. We would call that a pure discretionary bonus. However, quite often discretionary bonuses go on to set out factors that are taken into consideration by the employer when deciding if and how much bonus to pay. Factors tend to mean things like the employee's personal performance, the team performance, the overall profitability of the company and such like. This is where difficulties start to arise. Even if the bonus is stated to be discretionary, and often employers like to liberally pepper the bonus clause with the words discretion in every sentence, the courts will look past the word and examine how the bonus actually operates. There's a famous case in Hong Kong way back in 2002 called Wong, Huey and Colgate Palmolive, often shorthanded to be the Palmolive case. And in this case, the court of first instance said that a bonus that was described in the contract as being discretionary, but was calculated with reference to achieving operational targets, was not purely a discretionary bonus. In this case, it was accepted that a bonus could be contractual in nature, although it also has discretionary elements. This is what I mean when I refer to a hybrid bonus. The key question is whether the bonus could be described as being payable only at the discretion of the employer. It was on this question that the court answered no. Although the amount may be calculated with reference to some criteria that requires the exercise of discretion, the annual payment itself was payable by reason of the contractual provision in the contract, and provided the employees satisfied that contractual provision, then they were entitled to be considered for the bonus. It's just that the amount had a discretionary element to it. The court describes such bonus to be a contractual benefit, the calculation of which involves exercise of discretion by the employer, rather than a discretionary benefit pursuant to a contractual formula. So if you understand, it's important that contract comes first and then discretion second.
Right.
The significance of this is that it meant that the bonus was caught by the Employment Ordinance. And since the rules of the Employment Ordinance prevail over any rules in the contract, a bonus was payable to that employee. Now, in this case, I know I've been referring to multi-million-dollar bonuses, but in this particular case, the employee and the employer were actually arguing over 15,000 Hong Kong dollars. But thankfully they were, because it's created some very useful case law for lawyers and employees going forward. And it stands as the foundation block for bonus claims that are worth 10 or even 100 times more than there was originally in that case.
Okay, I can see why that is a hybrid bonus case. But what about purely discretionary bonuses? Surely an employee cannot claim a bonus that is totally at the discretion of his employer.
Okay, case law comes to the rescue again, and we need to go back a couple more years to the year 2000, and the English Court of Appeal case in Clark versus Nomura. In that case, Mr. Clark achieved profits for Nomura that were in excess of £6 million. Nomura exercised its discretion to decide how much bonus to pay him for that year, and gave him nothing.
Wow, that's really harsh. I guess that's why he sued.
Yeah. The court decided that an employee's discretion in deciding whether to award a bonus is generally subject to a test of, and wait for it, irrationality or perversity, referring to capriciousness as a good example. Very fortunately, in the last 20 years, the courts have started to refer to this by the less flowery term of reasonableness. So what they say is, would a reasonable employer have exercised his discretion in that way? If the discretion was exercised unreasonably, then it's a breach of contract, and the court would have to reach a conclusion as to what a reasonable employer would have paid to the employee in that position. So basically, the court needs to step into the shoes of the employer and decide what a reasonable bonus would be. In Clark, the judge decided to award him £1.35 million.
I see that this is a UK case, but is this good law in Hong Kong?
Yep, the Hong Kong courts have adopted this case. Actually, it was Nomura in Hong Kong that was one of the first to find themselves in the firing line. And the case is Post versus Nomura. And it was decided in 2001, so only 1 year later. However, Mrs. Post was not as fortunate as Mr. Clark. In that case, she was described as being a top employee and was therefore expected to receive top performance. And the court, when looking at what she did during the year, couldn't find any special or exceptional contribution on her part to merit a bonus award. So the court decided that it was not unreasonable for Nomura to have given her nothing.
So you have said that it is common for bonus clauses to state that to be eligible for the bonus, an employee must still actively be employed by the employer on the payment date. I understand that if it is a contractual bonus, an end-of-year payment, the Employment Ordinance will overrule this. But what happens if it is a purely discretionary bonus? Does that wording defeat an employee's right to argue for a discretionary bonus?
You're right. If it's not an end-of-year payment, the Employment Ordinance doesn't kick in and come to the aid of the employer to create a payable bonus. But what the courts have done in a very recent Hong Kong case is create what we call the implied term of anti-avoidance. Now, this came about in a case called Tadjudin versus Bank of America. In that case, both the court and the Court of Appeal agreed that an anti-avoidance term could be implied into an employment contract so that an employer cannot terminate an employment just to avoid paying a discretionary bonus. Now, in that case, the courts were very careful to say that this does not mean that every contract has an implied term of anti-avoidance in it. That being said, in the few years since that case was decided, many lawyers arguing for employees and employers always address the anti-avoidance term. And so whilst the courts were careful to say it's not implied into every contract, in reality, I think people have a pretty good shot of arguing anti-avoidance if they can establish that their employment has been terminated purely to avoid paying them that bonus.
It seems that there are many avenues available to employees to claim bonuses. What can employers do to protect themselves from such claims?
Good question. Well, we mentioned a little bit earlier that if you sack an employee within the first 3 months of the bonus year, then no pro rata bonus is payable. But there are a few other tips as well. So if an employer intends for a bonus to be discretionary, clearly and consistently state this in all documentation. If possible, don't include reference to any factors. Work on what we call the purely discretionary bonus. So don't refer to personal performance, company profitability, etc. Because that will be taken into consideration and start creating a hybrid bonus rather than a purely discretionary bonus. The problem we have with this is most employers want to hire the best employees, and the best employees are very reluctant to sign up to contract terms which don't guarantee them, or at least try and fix some criteria that relates to their bonus payment. And so it's a balancing act between giving the employees some satisfaction that they will receive a bonus and how much bonus they will receive, whilst not committing yourself to anything in writing. If you're going to provide a contractual bonus to employees, then you need to be very transparent and methodical in how you draft the performance formula and the criteria that are to be applied. What I would recommend for this is that instead of writing it in the employment contract, you actually write the formula or the criteria or performance thresholds in a separate document. Now, you could add it as a schedule or an appendix to the contract. And the reason I say this is because I would recommend including an express provision that an employer is able to change or vary the terms of the formula every year and reissue it on a year-by-year basis. If you do decide to do this, then the employer should make sure that they do actually reissue the terms each year, even if those terms are to remain unchanged. This will give the employer some flexibility to adjust bonuses, even though it's a formulaic contractual bonus. While I said that the traditional 13-month bonus is common in Hong Kong, because of the strict rules in the Employment Ordinance that govern such payments, employers are deciding to do away with it altogether. It's just too much like hard work. So therefore, you have to change the contract terms for the employees. To change the remuneration terms such as this would require mutual consent by the employee. So the question is, who would actually seek to give up their bonus? Well, what we advise employers to do is to change this contract term at about the same time as you do salary review. So you say to the employee, you will only get your pay rise if you agree this contractual term, which does away with the 13-month bonus. Now, if you're a fair employee, what you would do is you would divide that 13-month bonus over 12 months and add that as part of the salary review. But some employers are much more harsh than that.
This has actually been very informative, Adam. So how would you sum up this podcast?
Okay, in a nutshell, I would say that there's a lot of opportunity for employees to pick fight with their employers. Usually they will only pick that fight if their employment's ended, but you could in theory pick a fight with your employer whilst you're still an employee. And from an employer's perspective, with regard to bonuses, there are many, many pitfalls that they should be aware of.
Tune in and listen to more episodes of the Hip Talks podcast by checking the Insights section at our website at www.hugilandip.com and our channels on Apple Podcasts, Spotify, Google Podcast and Stitcher. They are also available on Hugill and Ip's YouTube channel. You can send comments and feedback to our email address, hello@hugilandip.com. If you found the Hip Talks interesting, please share them with friends, family and business associates. This podcast is for informational purposes only. Its contents do not constitute legal or professional advice.